everyone. My name is Shanti Abraham. I'm a panel arbitrator, adjudicator, and mediator with the AIAC. I say hello to all of you from Kuala Lumpur, together with my friend Hanif of AIAC. Now,
Hello.
today, Hanif and I have the distinct privilege to interview a doyen of the arbitration world, and that is no less Mr. Christopher Toh of Hong Kong. It is my privilege, before we start this interview, to share a little background of Christopher, who I am privileged to share, was one of my teachers in arbitration skills many years ago when there was a real push for more women in arbitration. Now, Dr. Christopher Toh is an independent mediator, adjudicator, and arbitrator who is on the panels of various leading global alternative dispute resolution bodies. He has arbitrated a variety of domestic and international cases involving both ad hoc and institutional arbitrations. He has mediated and adjudicated many international and domestic cases and has represented clients as counsel in cases at all levels, including the High Court, Commission of Inquiry, disciplinary proceedings, as well as international arbitrations and mediations. Christopher is an accredited mediator and chartered engineer, a chartered information technology professional, and a barrister of law. With that backdrop in mind, may I invite my fellow interviewer, Ahmad Haniffitri, to kickstart this conversation.
Hello, everyone, and thank you for the opportunity. Thank you, Shanti, again, and thank you, Mr. Chris. It is certainly an honor to have you with us today, Mr. Chris. Without further ado, I would like to start this webinar by asking you this. Having an engineering and computing background, what inspired you to pursue a career in law and, more importantly, establish a career in international arbitration?
Thank you, Hanif, and also Shanti for inviting me to come and speak. And good day, good afternoon, or good evening, wherever you are. It's a privilege to be invited by AIAC and CIArb to come and do this seminar, if you want to call it, or this interview. Now, when I finished from university, I was lucky enough to be employed by an airline in Hong Kong. And of course, in the department I worked in, had disputes involving components relating to aircraft components, and also, for example, the aircraft itself. So my boss one day said to me, why are we arbitrating disputes overseas, in particular New York? Why can't we arbitrate basically these kind of cases in Hong Kong or Asia? So I became curious as I was fascinated with the entire arbitration proceedings after attending a few arbitrations in New York. So I decided to search the internet to find out whether there are courses that I can learn from. So during this search, I came across the only course in Asia that was at City University of Hong Kong, relating to a Master's in Arts at the time, now Master's in Law, in Arbitration and Dispute Resolution. I quickly enrolled on the course without hesitation. I informed my boss I was going to do so, hoping that he would pay for my school fees, but unfortunately he said no. He says you have to pay it yourself. Never mind, I decided to pay it anyway because I was interested in arbitration. From that day onwards, I never looked back. I kept on studying. After my master's, I decided to pursue a Bachelor of Law degrees in honors at the same university, as well as qualify as a barrister to practice in Hong Kong as well. So my journey basically started off with engineering, but I ended up in law because I have a passion for law.
Wow, that's a fascinating journey, Christopher. Perhaps you can share with our audience how those crucial steps got you to be the doyen of the arbitration fraternity that we know you to be now.
Shanti, I don't classify myself as a doyen of arbitration fraternity. I just feel that I'm a person who's learning all the time. I like to learn. I like to engage people. Now, during my master's, knowing me, Shanti, I always ask questions. Okay? And there were questions about varieties of law that I'm not familiar with. At the time, I was a layman. I kept on asking these questions about, for example, there's two different types of law. How will they interact? So this concept of conflict of law was new to me. And I fondly remembered a lecturer called David Sandberg, who's now in California. He patiently explained to me the entire concept to me in very clear and precise examples, which today I can still remember. Now, another lecturer I think most of you are familiar with, a well-known and highly respected international arbitrator, and also a former High Court judge in Hong Kong, Neil Kaplan. In his classes, I kept on asking him questions. And guess what? He was very upset, I presume, because it disrupted his whole class. But nevertheless, this annoyance got his attention. And subsequently, after graduating, in a few years at my airline job, he came and asked me whether I would like to take on the position of Secretary General of the Hong Kong International Arbitration Center. I was only 29 years old at the time. At first, I thought the position was daunting, as those engaged in international arbitration, especially those I came across in New York, were all middle-aged, mature gentlemen, basically compared to myself. And I thought maybe this is not the right move. Nevertheless, I decided to pursue this. This is where I am today, and I have not regretted it at all.
Fantastic. It's amazing that your arbitration journey started at 29. I'm sure that's going to be very encouraging for all our aspiring young arbitrators out there. Perhaps you could share with us what you consider to be the 3 main highlights of your legal career to date.
I think the 3 main highlights, if I could say so, Shanti, is number 1, is being appointed as the Secretary General of the Hong Kong International Arbitration Center at the age of 29. I think this gives some encouragement to the younger generation to think about, hey, I can achieve that if I put my mind to it. The second one is there was a high-profile case, arbitration case. I cannot tell you the parties' names, but if I do, everyone will know them. I was appointed as an arbitrator, and it involves manufacturing a certain innovative product that we use every day, every minute of our life. Unfortunately, I can't say anything about it. As everyone knows, arbitration is confidential, and I decided on that matter. The third matter was, after qualifying as a barrister at law, within 6 months, I was approached by the complainant of a high-profile case relating to Marsh Transit Railway Corporation in Hong Kong. And that relates to the commission of inquiry into construction works at the Hong Kong Station extension under the Sha-Tin to Central Link project. And I was only 6 months qualified as a barrister in front of I don't know how many senior counsel in Hong Kong. And I was nervous, shaking, but I got through the day. And hopefully I represented my client to his liking, and he still basically considers me as a person he will hire in future.
That is absolutely impressive and remarkable. Certainly, it's not that easy to achieve, but you have achieved. So, what does professional diversity in international arbitration mean to you? And in your opinion, has this been achieved?
I know that gender is very important, but I believe that professional diversity means more to me than simply gender. It refers to the existence of variants of different characteristics in a group of professional people. Now, these characteristics could be anything that makes us unique within a certain industry, in particular arbitration, such as cognitive skills, personality traits, along with the things that shape our identity: race, age, religion, gender, sexual orientation, and cultural background. Now, in the context of international arbitration, it relates to the factors that contribute to a proper adjudication of a dispute, which disputants feel that justice must not only be done, but must also be seen to be done. This dictum was laid down by Lord Hewitt, then Lord Chief Justice of England, in the case of Rex and Sussex Justice. So in a way, I believe that professional diversity means more than just gender. It means what the parties really want, and they feel comfortable with the end result, whether they got justice or not.
You're absolutely right, Christopher. Most people when they talk about professional diversity, tend to only focus on gender. And you've mentioned that professional diversity means so much more than gender. I was wondering, Could we have some of your views on how to tackle this on the ground? I mean, in real life. And perhaps if you could share 2 strategies, what an institution like AIAC perhaps could do to assist, encourage diversity initiatives.
I think the first thing, Shanti, we have to look at is we have to take into consideration our customers. Our customers are the disputants. We have to take their views into consideration. So I think the first thing to do before any institution, whether AIAC or other institutions in Asia, before they start to appoint potential arbitrators from their list, I think they need to send out a questionnaire asking certain things. If, for example, if we appoint a female, would that be appropriate to you? In terms of age, would that be appropriate to you? In terms of, for example, religion and all that stuff, all these kind of things in a confidential setting, asking each party basically whether they have any preferences before we make it a choice. I think if you do that as an institution, you've actually taken into consideration the parties' perspectives in terms of what they want as the ideal dispute resolution resolver that they want to handle their case. I think that's very important. Now, the other thing that's very important that we haven't done very well, I think, not just in Asia, but the whole world, is about how can we sustain this education of diversity? Most people talk about it, and they do seminars here and there, but there's no drive. I think arbitral women is doing a lot in terms of diversity in this area, but it has to be sustainable. It has to be not just focused on a gender. It has to not focus on religion. It has to be focused on what the clients really want. If the clients want it, by all means, in future, they'll have more females. There are people more from ethnic minorities who are basically appointed as arbitrators. And then one last point I want to emphasize is we see a lot of conferences, especially international conferences outside of Asia. You basically get people, basically all I would say all Western panelists to talk about arbitration, talking about arbitration in Asia. And I think that what we need to have is maybe at least have 1 or 2 your ethnic minorities. You are sitting on those panels telling you about your experience of doing international arbitration from your perspective, being an Asian person. I was
going to say, you're absolutely right, Christopher. I think there's so much more about diversity that needs to be looked into. And what you've shared gives us a lot to think about going forward.
Yeah, I think, Shanti, because if we try to classify between female and male all the time, I think people are going to get sort of a bit, I say, locked on in the sense that basically going to have arguments. It should be a female, it should be a male.
Absolutely.
We have to look at, for example, what the client really wants. If the client wants a younger generation arbitrator, whether it's a female or male, then the client has chosen someone basically they really want to handle the case.
And I think, Christopher, you've identified another very important and underlooked area, which is the cultural diversity, which I think is something which will not really be pushed back upon, because cultural diversity can only enhance the experience that the parties bring to the tribunal. And that will not be such a polarizing topic for parties when it comes to deciding whether a person is suitable to sit on the tribunal or not.
Agree.
Yeah, we hope to see that a diverse range of panelists in international arbitration conferences going forward, like you do. So, Mr. Chris, how did you go about securing your first appointment as an arbitrator, and how did you find this experience?
I think my characteristics, I think yourself, Hanif, and Shanti know, I tend to be an outgoing person. I tend to talk to different people, I assume, okay? And what happened was one of my closest friends came to me and said to me, I have a dispute in my company involving a distributor, and basically the contract provides for arbitration. And I said to him, I'm not really that experienced. I've just basically finished the course. I'm not so sure whether I can handle this. He said, let's give it a try. So he actually asked the distributor whether they objected to my appointment, and the distributor said no. So I rendered the decision. Now, my experience at the beginning was daunting. Why? Theory is great, okay? But I believe now, you can't just learn the theory. It has to be in practice. You have to apply the theory to practice. And by applying that theory to practice, I actually learned 100% more than I did in university. Why? because you're faced with this dilemma of actually assisting the parties in terms of their requests, issuing procedural orders, and so forth. So from day one, by doing this case, I quickly grasped the ins and outs of the whole process of arbitration from start to finish, so that I now feel more comfortable. I wouldn't say 100% comfortable. I feel more comfortable in terms of doing arbitrations sitting on myself as a sole arbitrator.
Well, I think one thing I'm learning from you, Christopher, is that, really we must be proud to be lifelong learners. And this is something that I think even AIAC needs to be congratulated, because they facilitate these sort of conversations, which help all the upcoming aspiring arbitrators out there. Now, since we're talking about professional diversity, I'd like to ask a question about non-lawyer arbitrators. Drawing from your unique experience, do you believe parties and their representatives may consider non-lawyers when nominating individuals to form their arbitral tribunal? And perhaps in what sort of circumstances those choices are made?
Now, Shanti, at the start of my career, I did see a lot of non-lawyers being appointed as arbitrators. But now I see fewer and fewer. I don't know the real reasons for it, but I guess disputants and their legal representatives feel that having a legal issue resolved by a legal person would be best. Now, the concept of arbitration, especially within the Hong Kong context, which I'm familiar with, stem from the traditional Chinese preference for informal justice over litigation, which was deep-rooted within the local communities. Now, British officers performed some arbitral activities among Chinese and English traders even before Hong Kong established as a trade port. Now, I believe that certain disputes involving technical elements or heavy technical elements should ideally be resolved by technical persons who have some understanding of legal principles associated with contract and tort law. Where I studied engineering in Scotland, lay magistrates often handled cases in the court with the assistance of a clerk who is a lawyer who provided advice to the lay magistrate about the law. Some arbitration rules do have provisions of appointing experts to assist the tribunal. Maybe this is something we can consider promoting so that arbitration of the future does not become a club, but truly a legal fraternity, as we do need to cater for disputants' needs and to ensure that fairness has been achieved throughout.
Indeed, fairness has always been the goal in arbitration. As they say, fairness means everyone gets what they need. So in your opinion, Chris, what sort of insight or perspective do you believe those from non-legal backgrounds can bring into an arbitration proceeding?
Now, the biggest insight is their technical know-how, and this alone will facilitate the effective and efficient management of the arbitral process, as they are the ideal person given that they have the technical knowledge. As most institutions now are advocating ways and means to make the arbitration process more effective from a time and cost perspective. Why? Because disputants are complaining about the cost and the time to resolve a dispute. So these parties, who basically decide to appoint a technical person, can go through the dispute effectively if it only involves technical issues.
And so, Christopher, I just want to ask you, what sort of challenges do you consider those from the non-legal backgrounds? I know, what do they need to overcome to succeed in international arbitration?
I think the challenges, Shanti, stem from having no legal training, deciding cases of a legal nature, which some people feel that if they embark on choosing a non-lawyer, then there is a risk that non-lawyers will get the law completely wrong. And it could be detrimental to their case, as the chances of appealing an international arbitration award, as you know, Shanti, has limited grounds, unlike a domestic award. Non-legal practitioners do not need to qualify as a lawyer. They simply need to be acquainted with the law and the latest developments per se. I know of many famous international arbitrators who do not have legal qualifications, nevertheless, in high demand within the arbitration community. And one example from Hong Kong is Mr. Philip Yang. He is an arbitration practitioner who does not have any qualifications in law whatsoever, but other than becoming a fellow of the Chartered Institute of Arbitrators and also a chartered arbitrator.
Certainly, I agree with you, Mr. Chris. So what advice would you give to someone from a non-legal background as opposed to someone with a legal background who seeks to forge a career in international arbitration?
I think the key here, Hanif, is they need to pursue some legal qualifications in arbitration. And I know that AIAC does provide a lot of training, same with the CIArb in Malaysia. So maybe this is something they can embark on. Or sometimes they can shadow a counsel, doesn't have to be an arbitrator, to see how a counsel prepares for an arbitration, how they do advocacy skills, what are the issues they're going to focus on from their client's perspective. And also, for example, they can actually shadow an arbitrator or arbitrators in an arbitral tribunal. And also, very important thing is to actively engage and learn society activities through the CIArb and focus basically on arbitration and ADR. And hopefully, by doing so, you'll become known and people will see that you are one person that you can be considered for in terms of future appointments.
Absolute gems, Christopher. Thank you for all your insights. We have peppered you with some tough questions and really appreciate your candor. Let's end this interview on a future-focused question. What are your thoughts on initiatives such as the AIAC's Diversity in Arbitration Week in promoting professional diversity in international arbitration?
I think this is a very good sign, as AIAC has always been a leader in its field. In my dealings with the AIAC over the years, I believe the Secretariat does have the can-do attitude. They really want to change matters for the best to make Malaysia the leading dispute resolution center nation. I have every confidence that the AIAC will elevate the status of professional diversity in the international arbitration community going forward. Well done, AIAC, for leading the way. Your hard work will one day be highly noticeable globally. Thank you very much.
Thank you very much, Mr. Christopher To, for your time today. And thank you, Shanti, for your time as well.
No, it's been a real pleasure to speak to Christopher To and hear his wisdom. It's going to only take us forward, I'm sure. Thank you so much.
Hanif and Shanti, thank you for sort of inviting me and also to do this interview. And all I want to say to those budding upcoming arbitrators, mediators, the key to success is always stay positive, continue to learn. At the end of the day, your wish will come true.
Wonderful. Wonderful wise words. Thank you so much.
Yes. Thank you so much, everyone. For
Thank you.
yeah.